Today's webinar is Estate and Medicaid Planning Myths. And just a few housekeeping rules before we start. I will answer questions at the end, but if you can just hold your questions until the end by muting yourself. And then at the end, you can either unmute yourself or you can type your questions in the chat box. All right. So as I said, my name is Jane Marie Schaefer. I'm from the Herzog Law Firm and an estate and elder law attorney. I've been practicing for almost 28 years. So really have enjoyed working in this field and enjoy educating people on different areas in this field. So there's many estate and Medicaid planning myths out there, and that's why we have this webinar, just to kind of talk about them and break them down and get you the correct information. There's estate and Medicaid planning myths about powers of attorney, healthcare proxies, wills and trusts. There's also a lot of myths out there about Medicaid, about how you pay for nursing home care, how you qualify for Medicaid, what types of transfers of assets can be made, whether Medicaid pays for home care. So these are some of the things we're going to talk about today. So we'll start off with one, and the first one, it's an estate planning myth, and it says that I don't need a healthcare proxy or a power of attorney because my family can do things for me. And this is not true. You do need something in writing to have your family be able to do something for you or make decisions for you. Without a proper power of attorney or healthcare proxy, your family would have no power to do anything for you, and they would have to go to court to have a guardian appointed. Now, that being said, there are some things that you could do without these documents. So it's pretty common, for example, for spouses to be joint on a bank account. And if they are joint on the bank account, then that means either one can access the funds or pay bills. You could be joint on investment or securities accounts. But beyond that, trying to access other financial accounts, such as life insurance or retirement plan, you can't be joint on that. So if you did call to try and get information or do something with those accounts, most likely that institution would not talk to you unless you had a power of attorney, something in writing that showed that you could act on that person's behalf. And, just being, the spouse, they're not necessarily going to talk to you. That doesn't really give you any leeway with them to say that you have to divulge this information to me because they're not required to. So some of the more common things we see with the power of attorney is that if someone's, in a hospital or a nursing home, the power of attorney can sign admission agreements. They can contact your medical insurance to see what it will pay for. They can also use your power of attorney if you need to apply Medicaid or to create a trust to be eligible for Medicaid. So there's a lot of things that the power of attorney is necessary for, and that's why it's important to have those. In terms of a healthcare proxy, that may be a little bit more leeway if you're the spouse and your spouse is in the hospital and you go to the hospital, the doctors will probably talk to you and give you some information, but you're not really going to be able to make any decisions or access their medical records unless you have a healthcare proxy. And especially if you're not the spouse, if you're another family member, even more so, you need that healthcare proxy to be able to make medical decisions. Now, in an emergency, if you're in the hospital, there is something called the Family Healthcare Decisions Act, and that's only in an emergency situation where you're in the hospital, it's an end-of-life care decision. Then there is a law that defaults to your spouse or your children or your siblings to make that decision for you. But other than that extreme, end-of-life decision, you need to have a healthcare proxy in order to be able to do anything. So these two documents are really easy to do. And if you do these, then you can avoid a whole long cost and expense of having to do with guardianship, which is something that we'd like to try and avoid for you. Here's another estate planning myth, and this says that I don't need to have a will if I'm married because everything will go to my spouse. And this is a very common myth. So if you do have joint accounts with your spouse, as most people do, yes, they will go to your spouse, but only because you're joint on the account with them. And you typically would name your spouse as a beneficiary on your accounts as well. But even if you're married, many married people have individual accounts that are separate and in their own name. And if you die without a will, there's a law in New York called the intestacy law. And under the intestacy law, everything does not go to your spouse. Under the intestacy law, $50,000 plus 50% goes to your spouse, and the remaining 50% goes to your children. So if you did have a significant amount of assets, that is probably not what you intended, right? Most people intend for everything to go to their spouse after they die, so their spouse can live on that money. So this is just one example where the law is not exactly what you would expect it to be. So you can fix that rather easily by doing a very simple will. We call them I love you wills. And the will would say, when I die, everything goes to my spouse. So if you sign that and do that, then that overcomes this law that would give half to your spouse and half to your children. Some other things that you can do in the will that are important is that you get to pick who the executor will be. This is the person who's going to be in charge of handling the finances, paying the bills, and making the distributions to everyone. Another kind of myth with estate planning is, minor beneficiaries, right? So some people aren't sure what the legal age of majority is. Is it 21 or is it 18? And it's 18. That's the age at which a minor child would receive their assets outright. And frankly, for most children, 18 is rather young to get a large sum of money. Maybe a small sum of money would be okay. So this is what happens if you don't have a will. It goes to them. There's no way around that at 18. However, if you have a will, you can designate that anything that goes to a minor actually stays in trust for them until they get a little bit older and a little bit more mature. So you could say 25 or 30. You get to control when either your children or other grandchildren would receive their money directly. So that's another benefit of having a will. So this is another common myth, and this is that my revocable trust will protect my assets. And the answer is that a revocable trust does not protect your assets. Only an irrevocable trust protects your assets. And it's very easy to get these two types of trust confused, right? Their names are very similar. It's revocable and irrevocable. But if you can remember that the revocable trust is the one that does not protect your assets. And the reason for that is because you can revoke it, right? You're in charge of that trust. You set it up, you put money in it, you can withdraw money at any time, you could end the trust at any time. And because you have all that control over the trust, that's why those assets are not protected. Because if you did go in a nursing home and you had a revocable trust, there's nothing to stop you from taking that money out to pay the nursing home. So there are other good reasons for using a revocable trust. For example, a revocable trust avoids probate. Having a will does not avoid probate. If you have a will, you have to submit the will to probate in order to have your executor appointed by the court and to have the executor handle anything on your death. However, if you use a trust instead of a will, you do not have to file the trust with the court. You don't have to wait for any court approval. And your trustee can handle things upon your death. So that's another benefit to having the revocable trust, aside from protecting assets, because it does not protect your assets. And another thing I'd just like to point out when you think about trust is that you don't really have to be rich to set up a trust. Sometimes we talk about trusts and estate plans and it sounds very complicated, or you think you may have to have a lot of money to do one. But in fact, you don't. In fact, majority of our clients use a trust for their home, right? They're not putting significant amounts of money into their trust. And we'll talk a little bit about Medicaid and irrevocable trusts, and that's a common thing to use to protect your home. Or even a revocable trust, you could have just 1 or 2 accounts. It doesn't have to be a lot of money, and your house, and you could set up a revocable trust to handle those. There's just as many benefits to avoiding probate, when your estate's smaller as it is when your estate is larger. So the next myth, this is a myth we're going to talk about, and this is that Medicare will pay for my nursing home care. And this is pretty common. Many people get Medicare and Medicaid confused, and they use the terms interchangeably. However, Medicare is not the program that pays for your long-term care in the nursing home. Medicare does pay for some care in a nursing home. In fact, Medicare pays for up to 100 days in the nursing home following a stay in the hospital for rehabilitation. Medicare pays in full for the first 20 days, and for the next 80 days, there is a copay. However, beyond that, Medicare does not cover any of your long-term care costs. It's really only meant to help you, rehab or recover after, a surgery or a stroke or some type of medical incident. If you need ongoing care, either at home or in a nursing home, you're going to have to either pay for that privately, apply for Medicaid to pay for it, or perhaps use some other type of program like a VA benefit or long-term care insurance. So that's just something to keep in mind. That's the difference between Medicare and Medicaid. The other thing to keep in mind about the difference between those two is that Medicare is a program that for your health insurance that everyone is eligible for when they turn age 65. So that's primarily your medical insurance, and everyone has that. Medicaid is a separate program that you can apply for to pay for your long-term care costs. And to qualify for that program, your income and your assets have to be below a certain level, and you have to have some type of disability or be over 65, in order to qualify medically for that program. So there are differences between the two. So this is another Medicaid myth, and this myth is that I have to lose my home and everything I own to qualify for Medicaid. And unfortunately, this is what a lot of people hear, or they're told, or sometimes they're even told by the nursing home, that you have to spend everything down that you have until it's all gone, and then you can qualify for Medicaid. Now, without proper planning, that's true, because you would have to spend all of your assets down to $16,800 to qualify for Medicaid. So, without any planning, that's what you would need to do. And once your assets are gone, Medicaid would kick in and pay for you. If you're married, your spouse can have $74,820, and you can still qualify for Medicaid. So if you're married as a couple, you're allowed to keep a little bit more, almost $90,000 combined as a couple. Now, the other thing to know is, in addition to that amount of money, that either the 16 or the 90, if you're married, there are other assets you can retain that are exempt for Medicaid purposes. So, for example, your home is exempt if your spouse is still living in the home. However, if you're single, or if your spouse predeceased you, then when you move out of your home, it's no longer exempt. And Medicaid could put a lien against the home. But in some situations, the home is an exempt asset. Another asset that's exempt is a car. Also, retirement plans are exempt. And that's usually a good amount or a good percentage of someone's assets. And by retirement accounts, we mean 401k plans or an IRA plan. Anything that's in an IRA is exempt and not counted for Medicaid purposes. So there may be a situation where you have a home and you have a retirement plan and your cash assets are less than $90,000, then you could be eligible for Medicaid almost right away as a couple. If, however, your assets are more than those amounts, you would want to transfer assets to an irrevocable trust and protect them to qualify for Medicaid. And that's one tool that many people choose to do. So this is another Medicaid myth, and this is that I can transfer all my assets to my children and qualify for Medicaid. So as I just talked about, you can transfer assets out of your name, you can set up a trust to qualify for Medicaid, but you have to be aware of the look-back period. So you could either give gifts to your children outright, gifts to your grandchildren outright, give them a check directly. You could set up a trust and put money in a trust. That's considered a gift or a transfer in Medicaid lingo. And there's two different look-back periods because there's two types of Medicaid that you can apply for. There is Medicaid that is for a nursing home, and that has a 5-year look-back period. So you have to have set up a trust or gifted the money to your children out of your name more than 5 years before the time you need to go to a nursing home. So that really takes some advanced planning to do that when you're healthy, when you're a little bit younger, so that you comfortably get outside of that 5-year period before you may need to apply for Medicaid. For home care, so Medicaid also pays for care at home. That's called community Medicaid. And that's changing the law on that. Right now, there is no look-back period for community Medicaid. So I could gift money to my children and I could apply for Medicaid, community Medicaid next month. I don't have to wait because they're not going to care, or they're not going to look back. However, there is a change coming where there is going to be a 2.5-year look-back period for community Medicaid. Now that law was supposed to go into effect in October of 2020, but that got delayed because of COVID and federal emergency funding that New York State was receiving from the federal government. So that meant that New York State cannot change its Medicaid eligibility rules until that period of emergency is over. And, it's been extended many times as this pandemic has gone on. So right now we're anticipating around July 1st would be when this new 2.5-year look-back period will start to be applied to different individuals as they apply for Medicaid. So really, if you kind of step back and look at this, the best thing to do is to try and plan and transfer assets ahead of time before you think you need any care. This is a kind of common Medicaid myth, and this is that I can give away $15,000 per year to my children or grandchildren under the Medicaid rules, and I won't have a penalty for that. And this is not true, and this is where people are sort of confusing gift tax law and Medicaid law. And yes, it's true for gift taxes that you can give away $15,000. It's actually been upped to $16,000 this year per person. And for the gift tax purposes, that means that you won't have to pay gift tax on that amount, and you won't have to report that on the gift tax return. So that's very different. The gift tax rules and the Medicaid rules aren't necessarily the same. So even though I could give away $15,000 as a gift to my child, that would have no effect on me for tax purposes. It would hurt me for Medicaid purposes. And the reason for that is Medicaid looks back during the look back period at every transfer over $2,000. And what they do is anything that's over $2,000, they ask you to explain what it was for. And if you were purchasing something, or repairing your house or buying furniture, whatever, that's okay. If you gifted the money away, that's what Medicaid is trying to look at. So what they do is they accumulate all the transfers you made in the past 5 years, and they add them all up. And they take that total amount and they calculate a penalty period during which time you're going to be ineligible for Medicaid. So for example, if I over 5 years had gifted away something like 120,000, over the years. Now I need to apply for Medicaid. Medicaid would say, okay, you're not going to be eligible for the first 10 months that you're in the nursing home. And that's due to the amount of gifts that you've given over the past 5 years. So without knowing those rules, you can be really surprised when you apply for Medicaid, because now when you apply for Medicaid, you're in the nursing home. You've presumably spent down all your assets to $16,000. However, Medicaid would say, okay, because you made gifts, you still have to find a way in private pay. We're not paying for you for the first 10 months. So that's very complicated, right, and very tricky. So when we're trying to help someone who thinks they may need to apply for Medicaid for a nursing home, first we want to examine any gifts that were made and see if there's anything we can do about that to help plan for that. Another common myth, while I'm thinking of it on this one, a lot of people say, okay, well, if I gifted away money, Medicaid's going to make those people give it back. And they don't actually have the power to go to your kids and say, give that money back. They do deny you Medicaid. So maybe that has the same effect, right? Then you have to go back and ask your kids to give the money back, or your grandchildren, and you may not get that money back. So that's a little bit of a distinction there, but they're not reaching out directly, at least in taking that money out of your kids' names. They don't have the power to do that. So after hearing all of this, people think, okay, I can't give anything away and qualify for Medicaid, right? Because I'm going to be penalized, and there's all these rules about giving things away for Medicaid. Well, there are some exceptions to those rules, right, for Medicaid. So of course, anything before the look back period, before the 5-year period, is not counted. As I said before, when they look at anything over $2,000, if it was a purchase, it's not counted. So anything that you spent on your home or your medical care or a car, for example, is not going to be counted. And then there are the exemptions. There are some exemptions to these transfer rules. One exemption is transfers to a spouse are exempt. So remember how I had said that you can have $16,000 if you're applying for Medicaid, and your spouse can have $74,000. So what if when you apply for Medicaid, all of your money is joint? Well, what you're going to do is you're going to take the money out of the name of the person who's going into the nursing home, and you're going to transfer it to the name of the spouse who is staying at home. So when you're transferring money between spouses like that, there's no penalty there. You can realign how the assets are owned so that you meet those different numbers, those eligibility rules. If you happen to have a child with a disability, you can make transfers to that disabled child, and that's going to be exempt. You could transfer your house to the disabled child, or you could transfer money to the child with a disability, and that is an exempt transfer. Another common exemption is for caregiver children. So a caregiver child, if you move into your parents' home to take care of them, and you live there for at least 2 years to take care of them, then that parent can transfer the house to the caregiver child, and there's no penalty for that transfer to the child. It's, kind of, most people recognize that a parent will want that house to go to the child in someone in payment for helping to take care of them. And that's an exemption that's allowed. So if you don't qualify for one of these exemptions, right, you can still give away money. You just have to work with that penalty period and getting it done in advance and not last minute. So the next Medicaid myth is out there, and this is once I'm in a nursing home, it's too late to do Medicaid planning. And yeah, many people think this. They think, okay, now I learned that there's a 5-year look back period. Well, if I didn't do anything during that 5-year look back period, then I'm not even going, to try to do anything because it's not going to work. However, there's other things that you can do besides, transfer, setting up a trust, right, 5 years ahead of time. If it's kind of last minute, so let's say you didn't set up a trust and you didn't do any planning, and suddenly you have to go to a nursing home, you can still protect some of your assets. And you can save approximately half of your assets, even if you are already in a nursing home. And this strategy involves a gift and a promissory note. And basically you give away, without getting into all the details, but you give away about half of your assets to your family members. And then you use the other half of your assets to pay the nursing home. You set up a promissory note with one of your children and they pay you, and you use those funds to pay the nursing home. But kind of at the end of the day, you've saved about half. Now, this is why, so if you or your family member, your loved one is in a nursing home, and the nursing home is telling you that you need to either spend down money, you need to apply for Medicaid, it's a good idea to consult an eligible attorney, because the nursing home isn't going to tell you, for example, of one of these savings that's available to you. They're generally just going to tell you, okay, we can help you apply for Medicaid once you've spent all your money down. So you should offer, get a consultation, see what's going on, and see if you could save some money using this plan. Besides the half, it used to be called a half a loaf. That's another name for this, is because you could save half. Besides this half a loaf strategy, you may be able to utilize the exempt transfers that we talked about, transfers to spouse, spousal refusal is another technique. So there are some other things that you could do, even if it is a last minute. So Medicaid myth, this one is that Medicaid will not pay for home care. And this is pretty common. A lot of people don't know that Medicaid will pay for you to receive care in your home. And hopefully more people are learning about this option. The Medicaid at Home program is called Community Medicaid. And you receive a designated number of hours per care. It's going to be based on your needs. So some people may get 4 hours a day. Some people may get 10 hours a day. Really depends on your medical needs. And you can either use a home health agency to find home health aides. That agency finds the aides for you and takes care of, the scheduling for the aides. Or there's another program in Community Medicaid where you can find your own employees to work for you. So there's a couple different options under this program. Now, as with the regular Medicaid program, for Community Medicaid, you have to be financially eligible to qualify. So you have to have your income and your assets at those certain levels that we talked about before. If your income is too high, there's something you can do. It's called a pooled income trust for the excess income. So you can qualify even if your income is higher than the Medicaid amount. And again, I'm not going to go into all the details of that because we do talk about that in other webinars. But it's just good to know that Community Medicaid is a pretty rich program in New York State. I know there are other states that don't have as good programs. Some states have a program, but there's a long waiting list to get into the Community Medicaid program. So it is a good alternative to keep in mind when you're looking at how to plan for your long-term care in New York State. Okay, and now I have gone through the myths I wanted to talk about. So I will open this up. If anyone has any questions, you can either unmute yourself and ask a question, or you could use the chat box to ask a question. Everyone will receive an email with the PDF of these slides after the presentation. So you have them to look at, and you'll also have our contact information if you want to reach out with any questions after today. So does anyone have any questions? Let's see if there's any chats here.
Uh, Jane,
Yes.
if you already have a trust or you have a trust, do you need still to have a will?
That's a good question. And we always suggest you have a will, even if you do have a trust, because you may have assets in your own name. So you still want to have a will to take care of those assets, just in case.
I was not very sure if I understood when you said that in the will, if you have a will and you want to transfer or give to a child, a minor. Now, is there a special thing in the will that will require that you can transfer for a minor that has reached 18?
Well, if you don't put anything special in the will, the minor would get that money at 18. But in the will, you can create a trust for the minor. Now, you wouldn't do this if it was just a couple $1,000s going to a minor. But if you had a lot of money going to a minor, you would probably want to say they can't get that money until they're older, like 25 or 30, until they know more how to manage money. So that's only something you can do under your will, or a trust. If you don't have a will or a trust, there's nothing you can do. That child gets the money at 18.
So do I understand it correctly that, like, for example, I have grandchildren that have reached 18. I'm not sure. I have to review my will. I don't think I specified that, so they have to have this distribution from your estate, from your.
I would double check the will, and because, you've done your will with us, and most of our wills, we do have a default in there that it will at least go to age 25 or some older age. So it's most likely that's in your will. But you can check it, or I'd be happy to go over it with you.
Okay.
Anyone else have any questions?
I'm sorry, I have another one, which is not connection with the seminar. My senior moment, I forgot about the webinar yesterday that I enrolled in. Do I get the papers that you're gonna PDF or something?
Yes.
Even if
yes.
I was
if
not.
you signed up, yes, you'll get a PDF.
Okay, thank you.
Oh, so here, this is a good question. So this is for the intestacy laws. Are adult children included in that they get 50%, and after the 50% goes to the spouse? And yes, it does. It includes adult children, not just minor children. So again, that's not something you really would expect to happen. Your children could be married and supporting themselves. And if you don't have a will, suddenly they get half and you get half as a spouse. And that happened to a client of mine, actually, who for some reason the house was just in the husband's name. And so when he passed away without a will, the house went to the wife and her two sons, who were, adults. So luckily, in that case, and I would say most of the time, after they all received the house, the sons then agreed to turn it over and gift it back to their mom. So she ended up with the house. So, but you don't want to leave it up to that chance, right? You want to make sure that the spouse gets the house, so you're not relying on your kids to give something back to her.
How do you divide the distribution to the house and the adult children?
They would all be names on the deed. So the deed would have all of their names on it. That's how you share ownership of a house. But still not something you want to do if you can avoid it.